Layla Shaver, your favorite compliance nerd, and today I want to talk about outside business activities or OBAs. Yes, those other things you do outside your job that you're required to disclose. Sounds like bullshit? Sure, but there's a reason why you have to do it. So FINRA Rule 3270 requires registered representatives to disclose their outside business activities. But the difference here is you have to get pre-approval, which means your broker-dealer has to approve the outside business activity before you can initiate it. So it's really important that you are looking at the activity that you'd like to conduct and get pre-approval first. Why? Because you don't want to end up terminated over it. So we're going to talk about outside business activities, how to disclose them, what the firm's requirements are. We'll also discuss the RA side and how it works there too. So first and foremost, we have disclosure requirements when it comes to OBAs. You as a registered rep must disclose in advance to your firm what your outside business activity is going to be and get pre-approval. So if your firm rejects it, you can't do it. Doesn't mean you go and do it without them knowing. I know some of you who have and are continuing to do that. You're not supposed to because you'll get in trouble and potentially end up being terminated for cause, get a nasty U5, and then you end up with an 8210 request from FINRA being like, why the hell did you get terminated? What rule did you violate? It's a problem, and it can actually prevent you from getting a job somewhere else. So, pre-approval is required when it comes to outside business activities. And why? Well, the firm's required to supervise activities, but it's also required to tell the firm's clients, the investors, if you as a registered rep have conflicts of interest. And that can include other sources of income or revenue. That can take your time, that can take your attention. Maybe you're soliciting current clients to these other business activities, but the firm needs to know those things. They need to know how you're being compensated. They need to know potential conflicts of interest. They need to know how much time this is taking. There's a difference between an OBA being an Uber driver Friday nights because you live in a college town versus working as an insurance agent. There's a big difference in those OBAs. But if you're not sure which one to disclose them all. Your compliance team will figure it out. Now let's talk about potential conflicts of interest. I kind of highlighted it with the difference between being an Uber driver on a Friday night versus being an insurance agent. It is very common in our industry for advisors to wear multiple hats. They could be a registered rep, they could be an investment advisor representative, they could be an insurance agent. The broker-dealer is required to disclose these things to clients. What are all the hats and roles that you play? What are different types of compensation that you're receiving? Is there any incentive you're getting from these different business activities? That has to be disclosed because if you're having a conversation with your client as registered representative, but then you take off that hat and switch over to insurance hat, your client has to know that you can do that and that they don't necessarily have to buy the product through you. So it's really important to discuss this with your broker-dealer so they can make the analysis as to whether or not to accept your outside business activity. You want to discuss if you're selling any specific products. You want to discuss how much time away from your main role as registered representative this outside business activity takes you away from. But even things like you're invested in real estate and it's a personal investment could be considered an outside business activity. Setting up an entity, just an LLC, not doing anything with it, could be an outside business activity. What are the concerns we have? The LLC sitting there open but not doing any business? Very little risk. No conflicts of interest. You're not getting any compensation out of it. LLC where you're selling insurance products, you're soliciting clients of the broker-dealer to buy products through your LLC as an insurance agent, definitely conflicts of interest. So make sure you're disclosing this information because believe it or not, eventually they'll find out. And when they do, this is not a scenario where it's easier to ask for forgiveness than for permission. So what are the steps you can take as a registered rep to ensure compliance with this FINRA rule? First and foremost, understand the rule. Read it. Know that this is a requirement. You're in a heavily regulated industry. It is your job to know the rules and regulations that govern your job. So get to know them. Second, make sure you're making a full disclosure. By not giving all the information around this outside business activity, you can be seen as being deceptive, misleading, and that's all going to impact whether or not your OBA will be approved. So make sure you're making a full disclosure. Make sure you understand all the conflicts of interest that are inherent to the outside business activity in relation to your role as a registered representative. And do your best to identify what those are and talk to your broker-dealer compliance and supervision team about it. And finally, document everything. So often I talk to brokers, well, I had this verbal discussion with compliance and they told me it was okay. But then when I actually went and submitted the OBA, they said no, but I already started the process based on this guy or gal telling me verbally it was okay. Get it in writing. Because if someone just had a verbal discussion with you about it, they can deny it ever happened. And not even because they're being malicious about it. They may not even remember. Do you know how many people, compliance people, can talk to in a day? Especially at a big firm like an LPL or a Merrill, where you're talking to dozens of advisors every day. They may not even remember the conversation, which is why it's so important for you to make sure everything is documented. Now, quick caveat. This is a little different on the broker-dealer side than the RIA side. So broker-dealer side, we have to have pre-approval of the outside business activity. There's no hard and fast rule on the RIA side to get pre-approval. However, if your RIA requires pre-approval, then you would need to follow that policy. Otherwise, the other parts of disclosing your outside business activity remain the same. You got to disclose the time, the conflicts of interest, the compensation, products that you may be selling. You've got to let your firm know. So if you're concerned, if you have questions about your outside business activity, if you're worried about what to do since you already have one but haven't disclosed it yet, give us a call, guys. 770-462-2118. We'll help you get through this.